For the U.S. Supreme Court to agree to hear a case, at least 4 justices must vote to take it up. So not a majority, although it can be. 4 out of 9 is the bare minimum. It's the magic number. And now, with the news that the Supreme Court has decided to hear Donald Trump's claim that he is somehow immune from criminal prosecution, it begs the question, which of these 9 justices decided to take up this case? And why did it take the court so very long to do so? Now, on December 11th, 2023, special counsel Jack Smith asked the Supreme Court to quickly weigh in on Trump's presidential immunity appeal and to do so early, which the court rejected. And now, by the time we get to April 22nd, which is when the court plans to hear oral arguments in this immunity case, it will have been 133 days since the court was first asked to hear the appeal. So the pace is curious. Around 50 days when it appears to help Donald Trump, and over 130 days when it doesn't. Joining me now is Mark Joseph Stern, senior writer for Slate, covering the courts and the law, and Elie Mystal, justice correspondent for The Nation. Elie, first, let's talk about the optics of this order. It's unsigned. There are no dissents. I'm asking you to answer maybe the unanswerable, but do you think it's possible that this was a unanimous decision, that the liberal justices on the court co-signed taking this case up?
I highly doubt it. I mean, as you said, you only need 4 votes to take the case at all. Most likely it was the 4 horsemen, right? It was Thomas, Alito, Gorsuch, and Kavanaugh, the 4 horsemen of the apocalypse, who decided to hear this case. I'm a little bit more interested about the 5th vote, because remember, there was an option for the Supreme Court to take the case, but not grant the stay, but allow justice to keep forward, and they must have had a 5th vote to even gum up that process, so that most likely came from either Roberts or Barrett, or both. I doubt very highly that the liberals were in on it, but what I will say is that we've talked about, Dahlia was talking about Colorado earlier, right? The liberals apparently are going to allow Trump back on the ballot, and they got nothing for that. They traded away that for nothing, because the deal potentially of letting Trump be on the ballot but denying his immunity request, that obviously didn't happen.
Yeah, that seems to be somewhat up in smoke. Mark, I have to go back into the Wayback Machine, or the medium back machine, to revisit a conversation we had. I don't remember when it was. 2 weeks ago. Wow. 2 weeks ago. 7 years ago in TV anchor time. You suggested that the Supreme Court had already decided to take up the immunity case. You suggested that they had sort of maybe cleared their April calendar to take up a high stakes case. Can you talk a little bit more about what feels like a very prescient piece of analysis?
Yes, I'm saddened to learn that my educated guess was correct there. But what I noticed was that in December, shortly after Jack Smith first asked the Supreme Court to take up this case on an expedited schedule, the court was granting new cases but not putting them on the April calendar. One case in particular, a filing revealed that the court had secretly told the parties, we're holding this over until October, so you don't need to rush. In January, another major case, a death penalty case, the court rather bizarrely hung on to it and then held it over till next term. That was a strange pattern to me. I've covered the court for a long time. You usually don't see that. The justices like to clear their plates with these cases by filling up the calendar right until the end of April. And so that was why when we spoke a few weeks ago, or maybe a few years ago in anchor time, it seemed to me there was a real chance that what the justices were thinking was, look, we're going to have at least one more blockbuster emergency case. It will probably be the immunity case, and so we're going to hold open space for it later in the term. Again, just my guess, but I fear that in light of today's news, it is quite plausible.
Wait, if they did that, Elie, that is, first of all, I'm reminded of the Dobbs decision, where they decided they were going to take up the case but didn't actually put it on the docket for several months because of political realities, right? Could this court have done that again? And what does that suggest to you about, they could have taken this up in January when special counsel Jack Smith said, hey, can you hear this on an expedited basis, but chose not to. Then the appeals court gives a bulletproof ruling, as Dahlia says, and they still decide to take it up.
What it says is that they are corrupted political actors who act in bad faith. The reason why people like Mark and people like Dahlia seem to have a crystal ball is because they're real. because they're realists and they understand the court for what it is. And at some point, people in the media, people at home, and people sitting in the White House have to stop pretending that the Supreme Court is some kind of benign, trying to do its best institution and start to realize that there are 6 Republicans, not conservatives, Republicans on the Supreme Court who view it as their job to help the Republican Party. And until we do something about that, until we take away that power, until we draw the line on them there, they will continue to do this. They will help Trump. They will take away abortion rights. They will end affirmative action. They will liberalize gun rights. They will do all of it until we stop them. And somebody needs to start listening in the higher echelons of the Democratic Party, because we will keep losing every day we allow these 6 Republicans in robes to rule over all of us.
Mark, I so appreciate Ellie's passion and disdain for this court. I mean, it is an incontrovertible fact that when the 14th Amendment case rolled around, they were able to move that thing through real quickly, even though the stakes are as high, if not considerably higher in this case. And I wonder if there is any explanation that you could even fathom other than, craven political calculation.
So, look, I think there's a possibility that over the last 2 weeks, the liberal justices were trying to come to a compromise with a handful of conservatives. I think Ellie is right. Probably Roberts and Barrett were seen as the most gettable here to issue a summary affirmance, perhaps, of the D.C. Circuit's bulletproof decision, or to simply deny a stay. And, the court could have denied a stay, allowed the trial to move forward in the preliminary stages, and also heard arguments and rendered a decision to affirm that the trial could move forward in the summer. The court had other options, and I really do think that the justices on the left were struggling to find something, salvage something out of this over the last few weeks that would make it anything less than a disaster. But frankly, it appears that they have failed, and I cannot come up with any other justification for what the court has done here. Delaying over and over again, allowing Trump to run out the clock, but only in cases that he wants the court to move slowly on. As you've said, when he's bumped off the ballot, he gets to the court the next month. When he raises a bogus immunity claim, he gets to push his trial back so many months that it probably won't happen before the election. That is a disturbing pattern. I have to say, I am cynical about this court. Even I am shocked by what happened today. Last term, there were some decisions that suggested maybe a few of the justices in the middle would let us have some democracy, would let us have voting rights and make our own decisions and vote in a free and fair election and hold people accountable for subverting that election. And now I just don't think that's true. I have to agree with Ellie's extreme cynicism. I feel like this court is in the tank for Donald Trump.
Well, Ellie, in the break leading into the segment, you rightly point out the vested interest that some of these conservatives have in a re-election of Trump as it pertains to their retirement.
Clarence Thomas doesn't want to die on that court, and he's getting old, and he's never going to retire during a Democratic president. So Clarence Thomas, one of the reasons why he's not recusing himself is that Clarence Thomas needs Trump to win again so Clarence Thomas can retire. And most likely, Sam Alito needs Trump to win again so Alito can retire instead of having to die on the bench. And so that's at least 2 of the 9 who have a vested professional interest in seeing continued Republican hegemony over this country. And that's not the first time this has happened. As we all know, Sandra Day O'Connor wanted George Bush to be president and thus appointed him president in Bush v. Gore because she wanted to retire under a Republican president. This is how Republicans roll.
Wow. On that note, we are going to have to leave it there. The conversation is by no means over. Please come back, Mark Joseph Stern and Elie Mystal. Thanks so much for your time and your passions tonight. We have breaking news tonight. A judge in Illinois has disqualified former President Trump from appearing on the state's Republican primary ballot. Cook County Judge Tracy Porter cited the 14th Amendment's insurrection clause in her ruling, ordering the state's election board to remove Donald Trump based on his actions on January 6th. Illinois is now the 3rd state to disqualify Trump from 2024 primary ballots. The others are Maine and Colorado. As of right now, though, all three of these disqualifications are on hold pending a Supreme Court decision that could come down any day. Judge Porter acknowledged as much in her ruling tonight, writing that she knew her decision could not be the ultimate outcome. Now, whenever the court rules on this issue, it is sure to be considered in light of tonight's news that the court will now take up the question of presidential immunity in Jack Smith's federal election interference case. Joining me now to discuss all this is Mary McCord, former senior DOJ official for the National Security Division and an MSNBC legal analyst. Mary, thanks for joining me tonight. Some breaking news on all fronts. Let me first just get your thoughts on the immunity question and the degree to which the fact that the court is already mulling over the 14th Amendment case is at all a factor in the decision tonight on immunity.
Well, I know there have been people that have said ever since the court decided, to take up the 14th Amendment Section 3 question, and people listened to the arguments, and I think most of us who listened to them felt like the court is not prepared. There are not 5 justices prepared to bar Donald Trump from the ballot. They're concerned about a state having the ability to bar a presidential candidate from a ballot. I know a lot of people said, well, maybe they'll sort of balance that against a ruling either affirming the D.C. district in the immunity case or just not taking it up at all. I think, in the subconscious of the justices, those kind of balancing things out may exist, but I think they would very much deny that they do any type of horse trading like that, or that one case is related to the other in that way when the cases aren't technically related on legal issues. I do think it's interesting today to just think about the juxtaposition of this ruling out of Illinois with the decision to take up the question presented by the Supreme Court. So the question presented is the question that the Supreme Court has limited their review to is whether a former president enjoys immunity from criminal prosecutions for things that were within his official acts as president. So that we typically think of that from based on the law that applies to immunity in civil cases. Things that are within the outer perimeter of a president's official acts may receive immunity, but that question's never been asked for criminal cases. So when you think about what are a president's official acts, and on the same day as this decision to take up this case, we have a court in Chicago or in Illinois, like courts in other places, who have said Donald Trump engaged in insurrection. Just thinking about engaging in insurrection, the very thing that his criminal prosecution in Washington, D.C. is based on, engaging in this entire scheme that led to insurrection. It's hard to even conceive of that scheme as being within a former president's official acts. So the Supreme Court could have handled this much differently and said, we don't have to address questions about, in the generic space about whether a president could ever be immune for prosecution for things within the outer perimeter of his official acts, because here, this case in front of us is about a multifaceted conspiracy that led to an insurrection, an effort to overturn the votes of the American people. And whatever else you might say about official acts, that is not a president's official act.
Yeah, it just seems like the court has been handed a lot of data points, if not just very strong rulings, suggesting here's a person who fomented insurrection. Here's a person who has no claim to presidential immunity, according to the appellate court system. I mean, does it surprise you that they even feel the need to weigh in on this and that there was no noted dissent in the ruling today?
Well, you don't normally have a dissent from a grant of cert. You would have dissent sometimes from denials of cert, or you might have statements that sort of explain why cert was denied. So it would be unusual in the grant of a cert. I mean, a justice who is opposed to cert, there's a good chance that justice will ultimately be opposed to the ruling of the other members and can issue a dissent at that point. So I'm not surprised about that. I am surprised that it took almost 2 full weeks for them to decide to take this case. I can't imagine why they couldn't have known immediately, justice by justice, whether they thought that the case was important enough to take. And I've heard others say, and I don't disagree with this could have been an effort by some of the justices to actually convince others not to take the case. And maybe that's why it took this amount of time. They could have been also trying to hammer out what the actual question would be that they decided to take. But still, almost 2 weeks is surprising to me, and I think that's why a lot of us thought they would deny cert. In terms of my surprise about the justices, I think there's at least two who maybe want to side with the former president on this, or at least don't want to see him go to trial before the election. I mean, which is different than necessarily siding with him. But I think that most of the justices ultimately, I think, will come down on the same side that the D.C. Circuit did. And determined that on these facts, if they reach this, if they don't send it back to Judge Chutkan to determine whether this was within the scope of his official acts or not, but if they actually look at the facts of this case and address whether on a case with these facts that could possibly be immune from criminal prosecution, I think the answer will be no from a majority of the justices.
You sure would hope so. I know this is going to be the subject of an emergency episode of your podcast with Andrew Weissmann prosecuting Donald Trump, and I will be listening, Mary McCord. Thanks so much for your time tonight. The United States Supreme Court has once again created chaos. Today, the High Court announced that it will take up Donald Trump's immunity claim in late April, a timeline that could end the possibility of holding Trump accountable for trying to steal an election before Americans cast votes in another election this November. And the court is set to make one of the most consequential decisions in modern American history at the precise time when Americans are hugely distrustful of the institution and still reeling from the court's other recent decisions. Because of the court's 2022 decision to overturn Roe v. Wade, the future of reproductive health care, including abortion and fertility treatments, is now at risk. And then there's what the court did in the past 2 years. It ended race-based affirmative action. It blocked gun safety legislation. It allowed businesses to discriminate against LGBTQ people. This court has radically, unilaterally upended American life. And there is one man who, almost more than anyone else, is responsible for all of this. Addison Mitchell McConnell III, or Mitch, to his friends and foes alike. It was 8 years ago this week that Senator Mitch McConnell took one of the most unprecedented and consequential steps in the modern history of the United States Senate.
Republicans threw down the gauntlet today in the fight over the future of the Supreme Court. Senate Majority Leader Mitch McConnell said there will be no vote or even any hearings before the election on anyone President Obama nominates to replace Justice Antonin Scalia.
After the death of Supreme Court Justice Antonin Scalia, Mitch McConnell announced that he wouldn't even hold a hearing on any nominee President Obama chose to replace Scalia. Why? Because it was an election year, he said.
The next justice could fundamentally alter the direction of the Supreme Court and have a profound impact on our country. So, of course, the American people should have a say in the court's direction.
No one in modern history had ever actually stolen a Supreme Court vacancy from a sitting president until Mitch McConnell. And that decision had a profound impact on the future of the country. Trump won the election thanks to those votes from evangelicals interested in a Supreme Court appointment. And he went on to appoint Neil Gorsuch to the seat that had been stolen from his predecessor. The next year, Trump appointed Brett Kavanaugh to the bench as well. And as yet another presidential election year approached, people started to wonder, what would Mitch McConnell do if another vacancy opened up on the court? Would he help confirm a third Trump justice in an election year?
Supreme Court justice was tried next year. What would you do?
We'd fill it.
I would fill it. On September 18th of 2020, Supreme Court Justice Ruth Bader Ginsburg passed away. And with less than 2 months until the presidential election, Mitch McConnell rushed through the appointment of Amy Coney Barrett. That is how we got the radical conservative majority court we have today. This is Mitch McConnell's legacy. And today, Senator McConnell announced that he would be retiring from Senate leadership this November.
I'm immensely proud of the accomplishments I've played some role in obtaining. Still have enough gas in my tank to thoroughly disappoint my critics, and I intend to do so with all the enthusiasm with which they become accustomed.
So Mitch McConnell will no longer be running the upper chamber. After falling out with the former president, McConnell may be trying to wash his hands clean of the Trump-era Republican Party. The irony, of course, is that it is Mitch McConnell who, more than almost anyone else, abided Donald Trump and may have just helped him evade justice.